former Chief Justice of Nigeria, the Honorable Justice Mahmoud Muhammad, GCON, my brother justices of the Supreme Court serving and retired here present, the President and Honorable Justices of the Court of Appeal serving and retired, my lords, heads of courts and justices of various jurisdictions here present, Your Excellencies, the governors of Kano, Kogi, Katsina states, and former governor of Jigawa State, Alhaji Dr. Sule Lamido, CON, the Honorable Attorney General and Minister of Justice, ably represented by the Solicitor General of the Federation, distinguished members of the National Assembly here present, honorable members of the inner and outer bars, our esteemed royal fathers here present, distinguished invited guests, gentlemen of the press, ladies and gentlemen. I sincerely welcome you all to this valedictory court session in honor of our brother, Honorable Justice Abdu Aboki JSC OFR, who has made a remarkable imprint in his career and also in the development of his fatherland and the generality of humanity. He's an enigmatic personality whose name has become a recurring decimal in the annals of the Nigerian judiciary. Ostensibly for his annals of the Nigerian judiciary, for his robust scholarly disposition and alluring erudition. This valedictory session ought to have taken place on Friday, the 5th of August, 2022. But because of the annual vacation of the court, it has to be shifted to this date. So, for the records, Justice Abdu Aboki had ceased from serving as a Justice of Supreme Court of Nigeria since Friday, the 5th of August, 2022, upon his lordship's attainment of the statutory age of 70 years. My Lord, the Honorable Justice Aboki is a rare gem, a symbol of humility and piety that many look up to for inspiration and succor. His expertise in the dispensation of justice, which reclines on his mastery of law, stands him out as a man of dignity and distinction. His Lordship avidly pays meticulous attention to details, just as he always endeavors to leave a mark that owes the banner of integrity and honesty in everything he does. He has impressively offered 46 years of his life in service to his fatherland. If I say we are very proud of him, it will, as a matter of fact, be an understatement, because great men like my Lord, who are very passionate about what they do, are very rare, especially in our climate. By virtue of the lofty successes his Lordship has achieved, his name has no doubt been deservedly etched in gold and now occupies an enviable place in the Hall of Fame of the Nigerian judiciary. I have no iota of doubt that for many years to come, his Lordship astuteness in the application of law in all cases that came before him, which was largely complemented with outstanding judicial pronouncements, will not only adore the pages of our law reports, but will equally perennially resonate in our courtrooms. I feel so excited to felicitate with him on this very important occasion of his retirement from the Supreme Court bench. His Lordship exit from our fold has drastically depleted our ranks and opened a yawning gap that will hardly be filled. From a relatively encouraging number of 17 justices at the dawn of 2022, just like a flash in the pan, the number has suddenly dropped to 13 justices. Like we all know, a single drop in the number of justices here brings about a sudden increase in our workload, as the inflow of appeals to the court is ever on the increase due to the highly litigious nature of Nigerians. My lords, charismatic disposition and unwavering commitment to the cause of he believes in have literally conjured an aura of an enigmatic personality around him. We all rejoice and celebrate with his lordship on this epochal occasion that has been long anticipated, especially as the Almighty God has considered him worthy to enjoy good health and sound mind. Surely, his lordship's eloquent voice of inviolable judicial activism that had for several years adorned the airwaves of various courtrooms across the country will continuously reverberate and conscientize generations yet unborn. Honorable Justice Abdu Aboki was born in the sprawling commercial city of Kano on the 5th day of August, 1952. His lordship started his early education at the Native Authority Primary School, Kabawa, in 1960. Between 1965 and 1966, his lordship was at Sachuchi Primary School, Kano, to complete his primary school before proceeding to government secondary school, Adeja. His lordship was called to the Nigerian bar in 1977 after he successfully completed his law degree program at Ahmadu Bello University, Zaria, in 1976, and the mandatory one-year program at the Nigerian Law School, Victoria Island, Lagos. His lordship's insuperable appetite for legal education propelled him to the University of Washington Law School in Seattle, USA, in 1982. His lordship equally took time out for his busy schedule in the burgeoning law practice to attend the Nigerian Institute of Advanced Legal Studies, domiciled within the precinct of the University of Lagos, Akoka, Lagos, in 1985, and the Commonwealth Judicial Education Institute, Dalhousie University, Halifax, Nova Scotia, Canada, in 2006, respectively. While in the employment of Kano State Judiciary, his lordship served in different capacities and in various sensitive committees as well. He was Principal State Counsel, Ministry of Justice, Kano, between 1982 and 1983. Solicitor General and Permanent Secretary, Ministry of Justice, Kano, 83-84. Chief Registrar and the High Court of Justice, Kano, 85 to 87. His lordship was sworn in as Justice of Supreme Court on the 6th day of November 2020, alongside 7 other eminent judicial personalities, thus spending a rare short period of 1 year and 8 months on the Apex Court's bench. Even though his stint at the Supreme Court was short, his imprint on our judicature, as orchestrated by his lordship's eloquent judicial pronouncements, are glowing and indelible. He was clearly impressed on us. He has impressed on us the fact that it is not always how far, but how well. Samuel Johnson, a great philosopher, had said that it's not always how long one does something that matters, but how well he does it. Our brother, Justice Abdu Aboki, has eminently proved to us that it matters not how much time we spend on a particular task, but rather what impact and result we are able to achieve in the course of time spent. Our dear valedictorian is a specimen of doggedness, integrity, and humility. We admire him passionately within our fold, and I can assure you that so many people are queuing up to follow his footsteps in the outer world where his lordship is now going in a blaze of glory with impenetrable judicial sagacity. His Lordship had an elevation to the Court of Appeal in 2006 and was there up till 2020, when hard work, commitment, and dedication earned him a place in the Apex Court's bench. His Lordship was appointed a High Court judge in Kano State Judiciary in 1987 and strove to offer the best of intellectual insightfulness in the discharge of his judicial functions in different parts of the state till his elevation to the Court of Appeal in 2006. Among the various committees his Lordship served in the course of his judicial career include a member of the Committee to investigate allegations against individuals and authorities in Kano State in 1979, Chairman Kano State Rent Tribunal in 1980 to 1983, Director Kano Cooperative Bank Limited 1983 to 84, and of course, member of Kano State Board of Internal Revenue 83 to 84. Similarly, in 1999, His Lordship was appointed Chairman, Gubernatorial and State House of Assembly Election Petition Tribunal for Nasarawa State, Chairman, National Assembly, Governorship and Legislative House Election Tribunal for Kano State in year 2000, presiding judge, bribery, corruption, fraud, and other related offenses for Kano State 2001, and Chairman, National Assembly, Gubernatorial and Legislative Houses Election Petition Tribunal for Imo State, July to September 2003. Board member, Commonwealth Judicial Education Institute, Halifax, Nova Scotia, Canada, 2004 to date, among others. My Lord has traversed different countries of the world and presented academically enriching papers at different conferences and workshops bordering on the development of the justice sector to further whet the adjudicatory capacity of his audiences. Some of these intellectual masterpieces include Fundamental Rights under the 1979 Constitution, Annual Conference of the Nigerian Bar Association in Kano State in 1988, The Importance of Bail in the Administration of Criminal Justice, and Annual Conference of Magistrates and Area Court Judges in 1990, Special Lecture on the Criminal Trial Procedure in the High Court under the Criminal Procedure Code, Nigerian Law School, 1994, among others. In addition to the various scholarly papers presented, His Lordship also has a publication to his credit titled Fair Hearing and Bail. It's an article 2 cited as 2009, 1 NJILJ, pages 27 to 68. His tasking judicial functions, which were largely characterized by transfers across the country, had never in any way affected his domestic responsibilities as husband and father. From the various testimonies received on his personality, His Lordship took very good care of the domestic front and never failed to give the best comfort and attention to the nuclear and extended families. He's a man every woman will be very proud to have as a husband and every child as a father. His Lordship judicial pronouncements, which cannot be outlined here due to time constraint, have occupied vital pages of law books across the continent of Africa and beyond. He has been variously described by his retinue of admirers as a man of expansive scholarship and symbol of inspiring judicial activism. This is evidently due to His Lordship's meticulous attention to details, bravery, seamless deployment of disarming language, and alluring innovativeness in all his judgments. His excellent performance at the bench has attracted spiraling admirations and commendations from legal practitioners and judicial officers at all levels of courts in Nigeria. His various judicial pronouncements will, for a long time to come, have a foothold on logic and intellectualism. I make bold to say that our brother, Honorable Justice Abdu Aboki's imprint on the judicature and his dynamism all come through to show that he shares Lord Akin's view of the judicial officer, being that the essential role of the court is primarily to interpret the law in a way that the result will be just. The judiciary has a fundamental duty and an inescapable obligation to restrain the wickedness or the harshness of strict law in order to produce justice. The realization of this duty makes the Honorable Justice Abdu Aboki a judge in the Court of Equity. I sincerely thank you all for honoring our invitation. Next on our agenda is the address by the Honorable Attorney General of the Federation and Minister for Justice.
My Lord, the Honorable, the Acting Chief Justice of Nigeria, Honorable Justice Olukayode Ariwola, my Lords, the former Chief Justice of Nigeria, my Lords, the Honorable Justices of the Supreme Court, retired and serving, my Lord, President of the Court of Appeal, my Lords, the Honorable Justices of the Court of Appeal, retired and serving, Your Excellencies, Governors of Kogi, Kano, and Jigawa states, my Lords, Judges of the Federal and State High Courts, High Court of the Federal Capital Territory, and the National Industrial Court, the President of the Nigerian Bar Association, and all officers and members of the Nigerian Bar Association, distinguished senior advocates, distinguished members of the National Assembly, our royal fathers here present, distinguished ladies and gentlemen. I'd like to start by convening the apologies of the Honorable Attorney General for his absence this morning. He is unable to be here due to exigencies of his duty and has asked me to convey his apologies. I would now proceed to read his address. It is an honor and privilege to address the court on this special occasion on the retirement of His Lordship, the Honorable Justice Abdu Aboki JSC from the Supreme Court. We are gathered here today to bid an official farewell to a legal colossus, an exemplary judicial officer. As we have just heard, my Lord, the Honorable Justice Aboki has served in both the legislature, in both the executive and judicial arms of government, and creditably attained the zenith of his career in both capacities. Following his call to the Nigerian Bar in 1977, he began his public service career as a state counsel in the Ministry of Justice, Kano State, and attained the positions of Director of Public Prosecution and Solicitor General, Permanent Secretary of the Ministry of Justice, Kano. He was subsequently appointed Chief Registrar of the Kano State High Court of Justice and then a judge of the High Court of Kano State. He was elevated as a Justice of the Court of Appeal, where he served for 14 years as presiding Justices of Jos and Abuja Divisions of the Court of Appeal, before his meritorious elevation to the bench of the Supreme Court in the year 2020. In this very succinct account of his Lordship's short sojourn in the legal profession, evidence abounds to his efforts at limiting the excesses of the executive and the legislature, whilst also maintaining his integrity by an outward equanimity and fairness towards whatever issue is brought before the court. His Lordship has ensured that no matter what, the judiciary's independence is sustained by drawing strength from the pillars of our ground norm, the Constitution. His Lordship, in all his judicial pronouncements, never permitted isolationism between our Constitution and the independence of the judiciary. My Lords, His Lordship has indeed brought to the task of adjudication an acute sense of fairness and empathy in a system which depends on the integrity of process as a fulcrum of reaching right and just decisions and for preserving the dignity of litigants. His Lordship has without a doubt played an integral and outstanding role in the development of our law. His Lordship's opinions have always infused clarity and precision, no matter how complex the issues and how confusing the facts may be. Notable among His Lordship's pronouncement is in the case of Fawayimi versus the President of the Federal Republic of Nigeria, 2007-12 Nigerian Weekly Law Reports, Part 1054, wherein on the issue of local standi, His Lordship declared that in our present reality, the Attorney General of the Federation is also the Minister of Justice and a member of the Executive Cabinet, who may not be disposed to instituting an action against the government in which he is part of, as this may be tantamount to the federal government suing itself. Importantly also, His Lordship observed that there is no provision in the 1999 Constitution for the state to sue itself. He observed further that since the country attained independence from the colonial administration, he knew of no purported case of any superior court in Nigeria where the Attorney General of the Federation has instituted an action against the federal government or an Attorney General of a state suing state government on account of a violation of the provisions of the Constitution or a legislation contrary to the provisions of the Constitution. My Lordships, His Justice Aboki indeed clearly recognized that judicial opinions must be comprehensive, not just by comprehensible, not just by legal minds, but by the public laymen, that opinions of the apex court must provide guidance to judges at the trial court who implement these pronouncements. In his various pronouncements, His Lordship showed that the court should be willing to extend the ambit of local standi for the public good. It does take some wisdom and ingenuity to break such new grounds and expand the scope of the law on any principle. I would like to use this opportunity to once again assure the commitment of my office to the growth of a healthy relationship with this honorable court and indeed the entire judiciary in a manner that promotes genuine cooperation without undermining the independence of this hallowed arm of government. I equally solicit the continued cooperation of the Nigerian Bar Association and all legal practitioners in our collective task of easing the burden of this court. Together, we should make efforts to promote and foster the rule of law by encouraging this court through legitimate means to aid efficient and speedy dispensation of justice. Let me also use this opportunity to reiterate the commitment of this administration to the ongoing process of improving the remuneration and conditions of service of our judicial officers. Amidst revenue challenges as a nation and demands from all sectors for wage increase, the enhancement of the welfare of our judicial officers continues to remain uppermost on the agenda of this administration. In conjunction with the judiciary, we had proposed a few months ago, I believe, a comprehensive welfare package to cover salaries, allowances, housing, health, as well as professional development. This would, however, be done in line with constitutional and statutory provisions. I would therefore like to appeal for the continued patience and understanding of your lordships and other judicial officers, and assure that we do not take your sacrifices and commitment for granted. My lords, permit me to observe that in the year 2022, we have witnessed a steady reduction in the number of justices of the Apex Court. With the successive exits of my lords, Honorable Justice Mary Ukego Peter Odili, Honorable Justice Ejembi Eko, the former Chief Justice of Nigeria, Honorable Justice Dr. Ibrahim Tanko Mohammed, and now distinguished Honorable Justice Abdu Aboki JSC, the Apex Court has indeed returned to its pre-2020 numerical strength with just about 13 justices, as against the required 21 under the Constitution. We would therefore like to continue to work with the judiciary to ensure that these vacancies are filled as soon as practicable, in anticipation of expected surge in numbers of cases as we approach an election year. In closing, the Nigerian judiciary, and indeed the government of the federal of President Muhammadu Buhari, is enormously grateful for his lordship's contribution to the advancement of the law. I would like to say thank you, your lordship, for the honor and respect that you have always accorded to counsel appearing before you. You truly exemplify the culture of what the Supreme Court represents: precision, meticulousness, comprehension, and attention to detail. On behalf of the Federal Ministry of Justice, the federal government, and my personal family, I would like to wish Honorable Justice Abdu Aboki JSC a peaceful retirement at the end of a long, distinguished, and meritorious career in the public service. And I'll continue to pray that the Almighty God will reward him with good health and happiness. My lords, distinguished ladies and gentlemen, thank you for your kind attention.
Thank you very much, the Honorable Solicitor General and Permanent Secretary, Mrs. Beatrice Judy Agba. Next is the body of senior advocates of Nigeria by the able Professor B.O. Nwabwesi SAN, ably represented by Chief Okpoku SAN OON, to deliver the bosun's speech.
My Lord, Chief Justice of Nigeria, please permit me to stand on the protocol you have ably established for today's session. This valedictory session is a unique ceremony of the Apex Court to honor its retiring members who served and are adjudged to have served creditably well in honor, character, and learning. Honorable Justice Abdu Aboki has done so by his performance of judicial functions in the Supreme Court and in other courts where he served as a judicial officer. This is an honor well deserved. On behalf of the chairman, Professor Nwabwesi SAN, and the entire members of the body of benchers of Nigeria, I congratulate Honorable Justice Abdu Aboki for steering the course in the discharge of his duties to do justice. This valedictory court session is proof enough that his lordship discharged his professional duties well. I congratulate you. Occasions of this nature provide a good forum for the body of senior advocates to air its views on professional issues in the hope that those authority in the judiciary will consider them in the interest of the judiciary and our nation in the global village in which we all now live. The suggestions we make are designed to strengthen the administration of justice in our nation and promote and enhance the time-honored claim that the judiciary remains the last hope of the common man. In that way, the honor and dignity of our judges and their pronouncement will be readily appreciated and respected. The retirement of Honorable Justice Aboki immediately throws up an issue that has been very worrisome in the judiciary of our dear nation. The bar is aware that the number of justices of the Supreme Court has fallen short in recent times by reason of resignation and retirement of justices from the Supreme Court. Sooner or later, these vacancies have to be filled. The filling of these vacancies calls for appointment of new justices. This is where the body of senior advocate has issues with the method of selection and appointment of justice of the appellate court. The body has said it times without number and in various fora that the method of selection of candidates for appointments as justices in the Supreme Court and the Court of Appeal is unsatisfactory in the extreme. The appointment process appears to have been designed and operated to exclude good and competent lawyers in the legal profession from being appointed justice of our appellate courts. There are two aspects of this restrictive policy by the appointing authorities. The first is that the appointing authorities appear to have established a policy that the vacancies created by exit of a justice of the Supreme Court or the Court of Appeal are to be filled by picking a candidate from the state of the vacating justice only, notwithstanding the availability of known better candidates readily at hand from other states or local governments in case of judges at the trial courts. The consequence of this policy is that by it, our nation, our citizens, foreign citizens, and foreign and local businesses, businessmen and women who use and are expected to resort to the courts of law for restoration of their problems in Nigeria are denied the opportunity of having their cases considered and decided by appellate courts manned by the best legal minds the nation can produce at any time. This is a very sad reflection on our nation and the nation's judiciary. The policy of geographical spread in public service and in public life appointment is acknowledged today to be the foundation for the mediocrity and incompetence in some areas of the public service of our nation. The risk and dangers of mediocrity and incompetence in the Nigerian judiciary is too grave to permit by the policy of replacement or exclusion. The theory of replacement cannot bring about the best that is in us in the legal profession. At independence, many English and Commonwealth judges left the country. Their replacements were picked from among the best lawyers and judges of the time. The Right Honorable Justice Adetokunbo Ademola was lifted to the Supreme Court of 7 justices as CJN. The only other Nigerian justice of the Supreme Court was Honorable Justice Taylor. Both were Yorubas. Heaven did not fall. By 1964, the Supreme Court of 7 justices had Honorable Justice Ademola, Honorable Justice Onyama, Honorable Justice Koka, Honorable Justice Ajegbo, and Honorable Justice Idigben. These 5 justices are of Yoruba and Igbo. Those who manned the Supreme Court were the best the country had at that time. So we ask, what justification is there to exclude good, competent, and available candidates from the bar and operate the theory of replacement to be the basis for the selection and appointment of candidates to man appellate courts? The body of senior advocates takes the firm view that the selection and appointment of justices for appointment to the Supreme Court and the Court of Appeal on the basis of replacement is one that cannot result in the appointment of the best lawyers into the appellate courts in the country. The present number of the justices in the Supreme Court bench is 21. Obviously, every state or local government cannot have a justice of the Supreme Court from the state or the local government. So why then can we not walk across state of origin barrier and appoint for the highest court of the land the best material available to the profession and to our country? The agitation of the body of benchers in this respect will not go away anytime soon. Our submission to the appointing authorities is that the policy of replacement of the retiring justices from their place of origin is not sound and should be discarded. The National Judicial Council, as the appointing authority, should address this issue and appoint the best candidate of our country to man our courts. After all, justice is blind and so does not look at the face or see the face of litigants. Justice knows no tribe and has no color or religion. It has no specific location because it's everywhere. Let no one put on the Nigerian judiciary the ironclad case of restricting the appointment of justices in the manner we have complained about. Another sore point on the appointment of justices in our nation is the continued resistance or rejection of the necessity of appointing justices directly from the bar, as is the practice in other countries. Precedents abound in Nigeria. Honorable Justice Namani was not at any time a High Court judge. Yet, from the seat of Attorney General, he was appointed to the Supreme Court. The records of how Honorable Justice Namani performed on the Supreme Court bench are there for all of us to see in his judgments in the law reports. The Right Honorable Justice T.O. Elias, CJN, was an academician and later an Attorney General. He was never a High Court judge. Yet, he was appointed as the Chief Justice of Nigeria and the head of our judiciary, of the Supreme Court and our judiciary. Our advocacy in this direction is not a selfish one. The appointing authority, the National Judicial Council, knows that there are sound, honest, and hardworking lawyers in the ministries of justice, in academia, and in the private bar. There is sufficient pool of people in this circle that can enrich the work of the Supreme Court and the Court of Appeal. Bosan does not see any justifiable and arguable opposition against the direct appointment of this class of candidates available for appointment in the Supreme Court and the Court of Appeal. The lawyers in academia and at the bar read and write books and conduct researches just as the judges do. This skill to read and write legal opinion on appellate matters is undeniable. The lawyers from the private bar who practice law on a daily basis in all courts, and lawyers from the ministries of justice who conduct government cases have necessary skills that can greatly enhance the work of the appellate courts. Today, the National Judicial Council ignores these resources of recruitment and prefer to appoint candidates on the basis that they have served as magistrates and Sharia courts and customary court judges as a condition for appointment into the judiciary. During what I can now describe as the ongoing exercise, the former Chief Justice of Nigeria, Right Honorable Mahmoud Tanko, gave us the impression that at least one or two of the candidates outside the bench will be appointed as Justice of the Supreme Court to enrich the work of the court. On that basis, the Nigerian Bar Association, our umbrella body of lawyers in Nigeria, recommended 15 candidates. When the shortlisted list of candidates was released, regrettably, the appointing authority did not shortlist even one lawyer outside the judiciary as an appointable candidate. This is very sad, to say the least. The constitutional way of becoming a justice of the Supreme Court or the Court of Appeal is by way of appointment. Appointment of appellate justices is not a promotional exercise that one gets to the Supreme Court bench, and not by promotion from the Court of Appeal to the Supreme Court. A qualified justice certainly can be appointed, but that does not warrant the exclusion of candidates outside the bar on the ground that he was not a judge of either the Court of Appeal or the High Court. No one says that a deserving magistrate should not or cannot find his way to the Supreme Court by appointment. As long as he is good and sound, he is as entitled as any lawyer of the right standing to be appointed to the Supreme Court. I met Honorable Justice, speaking personally, I met Honorable Justice Ephraim I. Akpata as his Chief Magistrate in Warri, and I have the fortune of appearing for the accused person in the last case Honorable Justice Akpata conducted as a magistrate. You and I know that Honorable Justice Akpata made it to the appeal court from which, to the appellate court from which the Honorable retired. The issue of correct appointment of judges matters. We trust the right Honorable Justice, Honorable Chief Justice of Nigeria, and the National Judicial Council will look into this matter favorably. The bar and the bench are one. We all come from the same stable. There is no need to discriminate against members of the bar in the appointment of justices of the Supreme Court and justice of the Court of Appeal. In conclusion, both sides would like to remind colleagues, our judges and justices, that the season of acute challenge and temptation has commenced. Political parties are picking and or have picked their candidates, and it's already self-evident that litigation before and after election will increase. I need not remind your Lordship that this is a tempting period. Even this morning, if I may say this, I listened to Channel Television review of the newspapers. What did I find? A sign that they have discovered some people who are trying to use the courts to scuttle the work of INEC. That is a dangerous signal. For lawyers, there is need for us to keep strictly to our rules and not to fall victims of false values which we are faced with. We must uphold our rules of honesty and transparency and integrity. Our judges know what the profession requires. The moral duty to speak the truth and live by it in all life must not be thrown aside. Posterity will judge us harshly if we do. In my practice of law for over half a century, I have seen and learned in a very hard way that election and other political litigation pose the greatest danger to the rule of law and the administration of justice. In their ambition to stay politically relevant and or dominant, some politicians will go to any length to secure favorable verdicts, even when they and their lawyers know that they do not deserve such victory. In the process, they have no qualm as to the extent they want to compromise the administration of justice. The value of honor and justice we learned from our childhood and from our training as lawyers is then cast overboard and misplaced. A new philosophy of anything goes is resorted to. That is not the way or the goal of the legal profession. We should be reminded always that our laws must speak the same language in political or election cases as in all other cases and situations. Let us call to mind the immortal words of Lord Justice Hastings in his dissenting judgment in the case of Liversidge and Anderson, where he said, "In this country, amid the clashes of arms, the laws are not silent. They may be changed, but they speak the same language in war as in peace. It has become one of the pillars of freedom, one of the principles of liberty for which unreasoned authority we are now fighting, that judges are no respecter of persons and stand between the subjects and any attempted encroachment on his liberty." Then he went on, "I have listened to arguments which might have been addressed acceptably to the Court of King's Bench in the time of Charles I. We now have Charles III. I protest, even if I do it alone, against a strained construction put on words with the effect of giving an uncontrolled power of imprisonment to the minister. In our case, for the purpose of giving victory to an undeserving and greedy politician. Even if it was relevant to consider whether the legislation is absurd, Atkins said, "There is no absurdity or no such degree of public mischief that would lead to non-natural construction of electoral laws." Guided by these words of wisdom, let our colleagues at the bar who take up political and election cases and our judges and justices who hear political and election cases hold fast to the law in these times of challenge as it is at other ordinary times. Let us all, the bar and the bench, hold fast for all times the pledge by the judges of England in Magna Carta, signed into law on the 12th of June 1215, where it was proclaimed for judges, where the judges said, "Unto no one shall I deny or sell right or justice." Once again, I wish Honorable Justice Aboki and his family a happy, healthy, long life of joy in retirement. The statement by His Lordship, the Chief Justice of Nigeria, has described what is totally true of Justice Aboki, and the body of senior advocate endorse His Lordship's statement. My Lord, the Honorable Chief Justice of Nigeria, on behalf of the body of senior advocates of Nigeria, I thank you for the audience. Thank you, my Lord.
Thank you very much, Chief T.J. Opoku, SAN. That was a great speech. Next is the President of the Nigerian Bar Association, Honorable Yakubu Mekeao, SAN.
Thank you, my lords. And my lords, may I, with respect, adopt the order of protocol already established by my lord, the Honorable, the Chief Justice of Nigeria. I thank my lord, the Honorable, the Chief Justice of Nigeria, Honorable Justice Olukayode Ariwola, for this opportunity to address this hallowed gathering being held in honor of the quintessential jurist, the Honorable Justice Abdu Aboki, Justice of the Supreme Court. This valedictory session is one that I would not have missed as counsel giving my personal admiration for His Lordship. Few days after my inauguration as the 31st President of the Nigerian Bar Association, I had the unpleasant task of issuing a tribute to a colleague who had served as secretary when I was chairman of the MBA Welfare Committee. That became the first official communication I had to issue as president of the bar. I also attended a valedictory court session held in his honor at the High Court of Edo State, Benin City, on the 2nd of September 2022. This valedictory court session in honor of my Lord, Honorable Justice Abdu Aboki, will go on record as my first assignment before this honorable court as president of the Nigerian Bar Association. Valedictory court sessions, irrespective of the circumstance, are sober and solemn moments. They both speak to the nature of the positions we are or were privileged to hold in life and the fleeting nature of life itself. We are all encouraged, if not commanded by Scripture, to thank God Almighty, whether the gathering is with regard to the transience of the work we do or the life we live. Not many are privileged to witness or enjoy this sequence. It is therefore in appreciation of the grace of God upon the life of my Lord Honorable Justice Abdu Aboki, who saw His Lordship through an illustrious career on the bench, that we as members of the bar join in celebrating His Lordship's life of sacrifice to this nation. We are gathered today, as we all know, because His Lordship has attained the constitutionally prescribed age of retirement for Supreme Court justices. My Lord, who was born on the 5th August 1952, turned 70 on 5th August 2022. Let me, therefore, on behalf of the Nigerian Bar Association, wish His Lordship a happy birthday, though belatedly. Honorable Justice Abdu Aboki is an exemplary jurist. He deftly combines knowledge and integrity with the right demeanor and discipline characteristic of a judge. His Lordship is a thorough and disciplined jurist. Counsel appearing before a panel with His Lordship as a member or presiding must be prepared to answer straight and probing questions. These questions often go to the crux of the case or appeal, an indication of His Lordship's painstaking dedication to adjudicatory functions. There is no doubt that the exit of His Lordship from the bench of the Supreme Court has further reduced the number of justices of this court, with the attendant increase in the workload of the already overworked, overburdened, and unfortunately poorly remunerated justices. I call for the immediate appointment of additional justices to attend the full complement of 21 justices of the court, as prescribed by Section 231B of the Constitution. It is instructive to note, however, that even with the full complement of 21 justices, it will be a huge struggle for this court to cope with the number of appeals already pending before it, and those that are bound to arise, particularly from election-related matters. Needless to say that we are already in the season and the courts are inundated with political matters, leaving no time for consideration of other causes. This makes the amendment of the Constitution imperative to increase the number of justices to be appointed to the Supreme Court. A similar constitutional amendment should be made to reduce the number of matters that get to the Supreme Court. I recommend that the jurisdiction of the Supreme Court be limited to certain constitutional matters, as that will allow the court to properly function as the policy-making court that it is meant to be. My lords, the judiciary is no doubt facing several challenges, which include unfavorable working conditions, poor remuneration, docket congestion, analog systems in our courts, to mention just a few. All these take a toll on the health and well-being of the judges and justices. The Supreme Court of Nigeria is known to be the busiest and most overworked apex court in the world, notwithstanding the decades of neglect of the judiciary. The salaries and allowances of judges and justices have remained the same for over 14 years. This naturally affects their pension and gratuity, which is a function of their salaries at retirement. In the valedictory speech by Honorable Justice Ejembi Eko, Justice of the Supreme Court, held on the 23rd of May 2022, His Lordship observed that the issue of non-review of remuneration of judicial officers has remained a recurring decimal at the conferences of all Nigerian judges, and yet no action has been taken to remedy it. His Lordship said, the pertinent question is, who is in dereliction of the constitutional duty to review the remuneration, salaries and allowances of judicial officers since 2007? The NJC and the Federal Judicial Service Commission, as well as the Revenue Mobilization, Allocation and Fiscal Commission, should synergize and introspect and tell the world why the dereliction since 2007. Honorable Justice Eko went on to say, the plight of judicial officers who retired from the various state high courts, Sharia Court of Appeal, and Customary Court of Appeal is an embarrassment to the entire judiciary in the Federation. His Lordship went further to make some profound statements which cannot be ignored under any guise. He observed, the heads of courts in the Federation have enormous budgetary resources from which they can improve the welfare of serving judges. As it is presently, and as the Director of Budget in the Federal Ministry of Finance disclosed recently at the memorial lecture in honor of the late Abdullahi Ibrahim, Senior Advocate of Nigeria, at the Shehu Eradua Center, it is baffling that the welfare of judges remains in abject state in spite of the increase of budgetary allocation to the judiciary under this regime. Why? The said Director of Budget suggested that the panacea to the often touted underfunding of the judiciary will be for the judiciary to allow its books to be opened by the relevant authorities. This is clearly an illusion, albeit an indictment, pointing to the internal fraud attending to the management of the budgetary resources of the judiciary. Nothing stops the Office of the Auditor General of the Federation, the Independent Corrupt Practices Commission, and other investigatory agencies from opening the books of the judiciary to expose the corruption in the management of their budgetary resources. That does not compromise the independence of the judiciary. Rather, it promotes accountability. In most jurisdictions, the chief registrars, my lord said, regard themselves as direct subordinates of even the spouses of heads of court and allow themselves to be directed willy-nilly in the vandalization of the judiciary budget. The Nigerian Bar Association shall support all efforts necessary to ensure that adequate measures are put in place to guarantee the welfare of judges and justices while in service and for their comfort upon retirement. I commend to my Lord, the Acting Chief Justice of Nigeria, the recommendations for the reform of the judiciary made at the Justice Sector Summit organized by the NBA and Justice Research Institute in collaboration with National Judicial Council, the Konrad Adenauer Foundation, the United Nations Office on Drugs and Crime, and the Justice Reform Project. I also call on the federal government to revisit the 2018 report of the Committee on the Review of Judicial Salaries and Conditions of Service and consider implementing same with the view to bringing the emoluments of the judiciary in line with current economic realities. My lords, even if the report of 2018 were to be implemented today, it will certainly not meet the realities of our day. 4 years after that report was submitted to the Office of the Honorable, the Attorney General of the Federation, nothing has come out of it. As stated in my inaugural speech, I implore the judiciary to make its accounting books open and remain accountable to the Nigerian people for whom justice is being dispensed by the courts. Let me quickly state that the responsibility of the bar does not stop at ensuring that the welfare of judges and justices is guaranteed. While this is important to engender confidence, courage, independence, and productivity in the dispensation of justice, it is equally the responsibility of the bar to always show respect to the court. Some of our colleagues at the bar have made it good sport to leave courtrooms and go on air to attack judges and the judiciary for unfavorable decisions. His Lordship, Honorable Justice Abdu Aboki, in his characteristic bluntness, addressed this unfortunate trend of attacks on the judiciary when His Lordship spoke at the Nigerian Law School class of 1977 40th Call to Bar anniversary in 2017. His Lordship, then a Justice of the Court of Appeal, had this to say: "Most worrisome is the attack on the judiciary by the media and the members of the bar. This is a huge limitation on the development of the justice system. Before the court makes a pronouncement or a judgment, the media, with the help of legal practitioners, would have carried out its own trial and passed its own judgment on a matter still pending before the courts. This is indeed worrisome. We wonder at the role of legal practitioners. We wonder at the role legal practitioners play in all of this. You find legal practitioners on air daily, castigating judges and blaming them for all the woes in the justice system, and the media, of course, is quick to run with these sensational stories, spreading it as far as it can get. I think lawyers should put a rein on their utterances so that we do not, with our own hands, bring down the profession and legal system we have worked so hard to build. As for those who cannot do this and who continue to attack the judiciary without basis, they should be sanctioned." I cannot agree more with my Lord Honorable Justice Abdu Aboki on this. In a paper presented at the MBA section on legal practice in 2019, titled "The Bench and the Bar: Managing Our Symbiotic Relationship," I noted the challenges facing the bench and the bar in Nigeria are, for me, a manifestation of the crisis of identity that seems to have overtaken some, if not most, members of the legal profession. As a result of this, we witness amongst us conducts that are inconsistent with who we truly are and what we represent. This is true for all members of the profession, either serving on the bench, the bar, or other fields of legal practice. This lack of or misunderstanding of our true identity has adversely affected the relationship between the bar and the bench, and is largely responsible for the sharp practices we see amongst members of the legal profession, which has seriously tainted the perception of the public. Those involved in such practices are so few in number, but they have brought so much disrepute to the profession because they have remained resolute and determined to practice the law the way they do, either because they are ignorant of who they are, or they deliberately conduct themselves in that manner for their selfish pursuits. Neither is good nor acceptable. We must therefore, as a body, resolve to tame those erring members of the profession with the view to bringing to bearing and showcasing the fruits of our true identity. It is often said that the bench and the bar are in a symbiotic relationship. That, I think, is not correct. Symbiosis is a biological term. It is defined in Webster Dictionary as the consorting together or partnership of dissimilar organisms, as of the algae and fungi in lichens. The term ordinarily connotes an association which is mutually advantageous. The bench and the bar are not dissimilar organisms who found themselves in an association which is mutually advantageous. The bench and the bar are members or parts of the same body of a person known as justice, within a given set of rules or norms applied as the benchmark for ascertaining the presence of the person known as justice. Both the bench and the bar originate from justice, and it is the person of justice, and it is in the person of justice that we can find the bench and the bar performing their functions. In the discharge of our functions as members of this body, whatever appears adverse to the interest of justice should be fought jointly by the bench and the bar. The bench and the bar, properly understood, must, as a natural tendency, have symphony, harmony. They are concerted against any external force or influence that contends with the threshold set by justice, and they always resolve disputes to meet the demand of justice. And my Lord, let me pause here to say, what we have seen in law enforcement agencies, treating judges and justices the way they've done in the past, breaking into their homes and premises under the guise of investigating alleged acts of corruption or compromise, which conducts have been clearly supported by some of our colleagues when, like my Lord Honorable Justice Aboki noted in that remark he made, would go on television, even without the understanding of the facts of the matter, to castigate these judges or justices on mere allegation of corruption. My Lord, that must have been born out of the misunderstanding of who we truly are and our responsibility to the courts in the protection and the integrity of the court. That is a failure, and that we as a bar must deal with decisively. Because if we understand that we are members of the same body called to perform different functions for the purpose of justice, we would not conduct ourselves in that manner. An understanding of this relationship will see members of the bar conduct themselves with decorum, respect, and candor while performing their roles before the members of the bench. The bar will not abuse the bench. It will not collude with strangers to harass and disparage the bench, and will not rejoice over any ordeal that befalls the bench. My Lord, it's like the hand rejoicing over what has happened to the eye of the same body. That should not be the case. The bar disparages the ban and will not rejoice over any ordeal that befalls the bench. Rather, the bar will be protective of the bench and will not compromise, will not conspire with aliens to wreak havoc on the institution of justice. While we must not and should not condone the practice of corruption in any form or guise, an understanding of our identity, we see us approach matters differently. It is not unusual that the few challenges that we already identified would rear their heads sometimes. When they do, we must use established channels to settle the issues without smearing the image of the otherwise hardworking members of the Nigerian judiciary, who toiled to dispense justice in very difficult conditions. I will continue as president of the Nigerian Bar Association to champion the need for this harmony between the bar and the bench. My Lord, the negative reports we get about our judges and justices, they come from just a few out of the judges and the justices that we have in this country. That is certainly not a representation of our judiciary. And it is our responsibility to say so to the world, so that we do not allow the narrative to be controlled by the few bad eggs that we have within the legal profession, and then determine the perception that the public would have about the Nigerian judiciary or even the international community. The Independent National Electoral Commission, and indeed the nation, is preparing for the 2023 general elections, which promises to be a watershed moment in our democratic experience. It is safe to assume that the result of many of these elections will become the subject of adjudication. Consequently, the ultimate outcomes, for the most part, does not lie with INEC, but with the legal professionals on the bench and on the bar. We therefore owe Nigerians a sincere participation in the process. My lords, staying on this subject of the 2023 elections, I must observe that your lordships and the entire judiciary work all year round, save for the known vacation period, which is not even total, as vacation judges are appointed. Your lordships hear and determine thousands of cases ranging from land matters to chieftaincy, contract, succession, maritime, intellectual. Election petition represents less than a significant proportion of what your lordships do. However, given the public interest that these election matters herald, they often pervade the media attention and almost entirely characterize the perception of our judicial adjudicatory system. Your lordships and indeed the legal profession are right at the center of public attention when we take on election petitions. All our actions and utterances are observed and scrutinized, and they define how the public perceives us beyond the election cycle. Put differently, members of the public define our entire careers by the way we conduct ourselves in the limited period statutorily limited for election matters. I call on your lordships and my colleagues at the bar to remember this fact and to conduct ourselves with the highest level of professionalism, integrity, and probity. We must be beyond reproach in all that we do if we must preserve the legal profession for generations yet unborn. My lords, ladies and gentlemen, upright and hardworking as the generality of the bench and the bar, we know that there are bad eggs amongst us. When we identify them, as we often do, we must quickly set up necessary procedures to isolate and discipline them in the overall interest of the profession and indeed the nation. This is a responsibility we owe our calling to this profession, noble profession. As president of the Nigerian Bar Association, I undertake to cooperate maximally with your lordships, the National Judicial Council, and the Legal Practitioners Disciplinary Committee to rid our profession of these few bad eggs. I seize this opportunity to warn our colleagues at the bar as we go into 2023 election that there will be consequences for your actions and inactions that threaten to ridicule our profession. We must always, in the discharge of our calling, either on the bench or at the bar, be motivated only by the desire for justice and the enthronement of the rule of law. My lords, implicit in the reference to courts as citadel of justice is a direct reference to our functions as ministers in the temple of justice, a function that must be performed with integrity and circumspection. And my lord, this puts us in a special place, special pedestal. There is no other professional on the face of the earth that is qualified to perform any function with respect to the delivery of justice to the people. And that is what our society dearly needs. So we are called into this privileged profession, a noble profession at that. No other person will do that. It is this legal profession, either serving on the bench or at the bar, that would provide that necessary leadership that we require for this country to get out of the mess that we experience today. In the case of Eyre versus Sussex, the English High Court of Justice, following a long line of cases, established the principle that the mere appearance of bias is sufficient to overturn a judicial decision. There the court held, it is not merely of some importance, but it is of fundamental importance that justice should not only be done, but should manifestly and undoubtedly be seen to be done. Nothing is to be done which creates even a suspicion that there has been an improper interference with the course of justice. Putting forth this point a bit more succinctly, the former Chief Justice of the United States District Court, Chief Judge, United States District Court of Columbia, in her address to the Bar Association of St. Louis, titled Law and the Layman, stated that there should be two cardinal objectives of justice in a democracy. One is obvious: courts must accomplish justice. The second, often neglected, is courts must convince those whom they serve that justice is being accomplished. To this end, my lords, members of the bench, in carrying out the functions of their office, must always bear on their shoulders the duty of ensuring that there is no appearance whatsoever of compromise on their part. Nothing should be done which creates even a suspicion that there has been improper interference with the course of justice. As a wise man once noted, Rule of law is only achievable when members of the society have confidence in the integrity and capacity of the judiciary. It follows, therefore, my lords, that as members of the legal profession, we must be deliberate about pursuing the cardinal objectives of justice. We must deal decisively with any issue amongst us that will lead us to ridiculous characterization by the public. This is the only way the legal profession will elicit the confidence of the public and remain relevant in the affairs of this nation, while not ignoring the negative impact of several decades of neglect which the judicial arm of government has suffered in the nation. And like I did at the legal year ceremony of the Court of Appeal, I call upon the federal government. And my lord, at this point, I had said it in several fora. And this is my opinion, and I think I have reasons, and I'm persuaded by this opinion, that there has been a concerted effort by government to pauperize the judiciary. And that is why, my lords, it is comfortable for government over the years to not consider the review of the salaries and allowances of judges and justices. Only recently, my lord, we saw an improvement on the allowances given to permanent secretaries and other senior civil servants. They never had to complain. There was never a time that we heard the members of the legislature complain about lack of pay of their salaries and their allowances, or that they do not have basic tools to conduct their work. Why the judiciary? Why? Who is interested in making sure that the judiciary does not do its work? And my lord, no serious government anywhere in the world would ignore the function of the judiciary. This court and the judiciary of this nation is responsible for the stability that we've enjoyed so far in this country. It's been responsible by the decisions that your lordships have rendered in several of the cases that your lordships would have to deliver, that guaranteed the sustenance of this country as one polity. That cannot be ignored by either the legislature or the executive. But what the courts get for keeping this country together is neglect. No country grows without making deliberate investment in the judiciary. It's not a question of even comparing what the legislators get as a benchmark for what the justice of the Supreme Court. My lords, legislators are elected for a certain period of time. Your lordships have been serving this country for decades, and then your lordships will leave after serving this country meritoriously, after keeping this country together from your pronouncements, and may not even have a place to retire to. That is totally unacceptable. That is not to show gratitude for the arm of government that is responsible for the peace, relative peace that we even enjoy in this nation. And in several respects, what your lordships have done have also been undermined by the same group of persons that have considered it palatable, if you like, to make it impossible for the judiciary to do its own work. So, my lord, I call on the federal government to make deliberate and conscious investment in the judiciary to engender development in our nation. The bench, supported by the bar, must continuously strive to command the confidence of the society. In the lecture titled Dissenting Judgments and Judicial Lawmaking, in honor of Honorable Justice Adolphus Godwin Karibi White, Justice of the Supreme Court of blessed memory, my Lord Honorable Justice Oguntade, Justice of the Supreme Court, had this to say: a judicial system thrives when, by its judgment, it instills confidence in the larger society that it is fair, impartial, and corruption-free in the adjudicatory process. A judiciary that is weak, corrupt, or unreflective of the people's aspiration is irrelevant to the people and doomed to collapse with time. Freedom, peace, order, and good governance, the essentials of any democratic society, depend on responsiveness on the part of the court in the performance of judicial functions. The law as an instrument of social change will remain so only in the name if the judiciary is not responsive in applying or interpreting the law to bring about change whenever and wherever the situation calls for it. And my Lord, this is only a responsibility that the courts can perform. The executive cannot do it, the legislature cannot do it. So if we need change in our society, it is only the courts that can make that necessary, create that necessary atmosphere, create that necessary basis for change to happen. Because justice is what everybody is looking for. Our experience today is just an indication of the absence of justice. And there is a deliberateness. My Lord, I don't mind saying it over and over again, because this is what we have experienced. My Lord, it is inconceivable that 14 years, your lordships remained with the same salary, in spite even the inflation that we experienced between January and today, 2022. Is enough for your lordships to go home with pay that no other person in this country gets. And that is my sincere position. I noted in my inaugural address that the only voice which cannot be suppressed is the voice of the legal profession. My Lord, your voices cannot be suppressed because it derives from its source, from justice. Whatever anybody does, you cannot kill justice. That is where your lordships derive your voices, from which you make pronouncements that helps to put this country together, that dispenses justice to the people. Public resentment has grown against members of the executive and the legislature. We all know it. The public no longer sees them as providing the representation for which they were elected into their various offices. Challenging as it may be for the judiciary, it remains the only resort for the Nigerian public. Honorable Justice A.M. Amadi, the former Chief Justice of the Supreme Court of India, had this to say on this point. And my Lord, I must quickly say that I'm making reference to the Supreme Court of India, not because the Indian Supreme Court is by any stretch of imagination even comparable to the quality of our court or our apex court, but it's just to illustrate the point. I found this pronouncement apt and I thought I should use it. So I do this with due respect and deference to this court. In recent years, the Chief Justice of India said, as the incumbent of Parliament have become less representative of the will of the people, there has been a growing sense of public frustration with the democratic process. This is the reason why the Supreme Court had to expand its jurisdiction by, at times, issuing novel directions to the executive. My Lord, this court must assume that posture. And when my lords do that, heavens will not fall. Nothing would happen, but your lordship will simply be doing what you are called to do constitutionally to set things right in this country. In what was a show of strength of character, though not surprising, when the issue of Order 10 came before this honorable court, it was meant to be an order that would serve the interest of this court and other members of the judiciary. But my Lord said no, that this does not line up with the rule of law. And even though it appears to serve our interest, but you can't treat us this way. We've risen above that sort of beckoning. You can't beckon on us simply because you have given an order when it does not line up with even the document that has set up both government and the arm and the judiciary. My Lord, this must be the posture of this court and indeed all other courts in this nation. If we are to experience the much desired recovery, reformation, and repositioning in our polity. My Lord, it calls for courage and boldness and, of course, the support of the bar. And my Lord, the Nigerian Bar Association, under my leadership, is committed to an unflinching support for the judiciary in this regard. I must have stated, I noted that I made reference to this case, not because India is anyway better than us. My Lords, having appeared before my Lord Honorable Justice Abdu Aboki severally and having read his many decisions and interacted with him personally, it is my humble respect respectful opinion that His Lordship has executed his judicial duties creditably. He has left an indelible mark in the history of the Nigerian judiciary, from the High Court to the highest court of the land. Now that His Lordship is done making judicial pronouncements, his judgments will continue to speak for him in many decisions that follow His Lordship's precedents. At this juncture, I wish to remind my Lord, Honorable Justice Aboki, that every end is a new beginning. As my Lord's judicial career, spanning almost 4 decades, has come to an end, it is the beginning of another stage of your Lordship's impactful life. I urge your Lordship to enjoy the well-earned rest with your family, from whom we have kept you away for far too long, even as I apologize in advance for occasional interruptions as we come back to seek your Lordship's advice on knotty issues. My Lord, the bar will keep coming to your Lordship, probably even next week, so soon after your retirement. We thank my Lord Honorable Justice DJ Abdu Aboki of the High Court of Kano State, who is known as a judicial gem in his own right, for the support to His Lordship and throughout his judicial career. My Lord, just so that we remind your Lordship that your Lordship has gone into retirement, let it not be that when my Lord Honorable Justice DJ renders a decision, my Lord begins to view it from that appellate pedestal. My Lord is in retirement. What my Lord Honorable Justice DJ now expects from your Lordship is more affection, more love. That, my Lord, we did not allow my Lord Honorable Justice DJ to have, because we have kept you working for the nation. So, my Lord, we would ask most respectfully that my Lord would do a recalibration so that my Lord would properly accommodate, because my Lord, the Honorable, the Chief Justice of Nigeria, had earlier indicated no one would want to miss your Lordship as a husband. So, my Lord, it's your responsibility this time on retirement. All the perquisites, all the benefits that are due from that privilege of having your Lordship as a husband should be accorded without any restraint. We similarly appreciate the children, 2 of whom are magistrates, as we release His Lordship into the warm embrace of your grandchildren. Finally, my Lords, on behalf of the Nigerian Bar Association, I wish your Lordship a long and healthy life in retirement, to enjoy the fruits of your labor on the bench. May your Lordship grow from strength to strength, to the glory of God Almighty. Amen. I thank this honorable court once again for this opportunity, and I thank everyone for listening. I'm grateful to your Lordship.
Thank you very much, the #1 lawyer in Nigeria, Honorable Yakubu Makiyawu, SAN. We shall now listen to the man of the moment, His Lordship, the Honorable Justice Abdu Aboki JSC CON, for his response. My Lord.
My Lord, the Chief Justice of Nigeria, Honorable Justice Olukayode Ariwola, my brother Justices of the Supreme Court, retired Chief Justice of the Supreme Court. In particular, I could see Mahmoud Mohammed, my mentor, and other Justices of the Supreme Court retired. I also recognize Justice Olufumilayo Adeke. She was referred to as my mama from the Court of Appeal to the Supreme Court. Amiru Suleiman Galadima, and the rest. The President of the Court of Appeal and the Justice of the Court of Appeal serving and retired. The governors of Kano, my governor, the governor of Jigawa, retired governor of Jigawa, my brother, the governor of Kogi, my brother, the governor of Katsina, my good friend, Rochas Okorocha, and Governor or Administrator Omerua, and other royal fathers here present. I recognize the representative of the Megiddo of Lokoja, the Ndarman of Lokoja, Mala Nasir Ahmed, and other representatives here. Learned senior advocates of Nigeria, I'm sorry, the judges, the heads of court of the courts in Nigeria, the High Court, Court of Appeal, and the Customary Court, and judges of those courts, and then the senior advocates of Nigeria. Ladies and gentlemen, I think I'll stand on the existing protocol. I was born on the 5th of August, 1952. In fact, there's confusion as to where I was born. Some say I was born in Lokoja, some say I'm born in Kano. But the history is that I was born in Lokoja, into the family of Sharif Abdu Aboki and Hajia Khadija Kaka Kubra. My father was from the Sharifai ward in Kano City, the Ala local government of Kano State. My full name is Abdul Karim. And why I have beard, I've retained Abdu. When I was born in those days, the names are not given to a child until after 7 days. And that name is kept a secret until the day of the naming ceremony. So in my case, my uncle, who was to pronounce the name, whispered that my name is Abdul Karim. That is the father of my mother's father. That's my grandfather. So when he went into the women's section, they said, "What is his name?" He said, "Abdu." So my mother was so happy because her father's name is Abraham. So she thought that is her father. The people on my father's side were also happy because it's Abdul Karim. That's their decision. Then my father's friends and the clerics said, "This is Abdul Karim Al-Magili, the great Islamic scholar." Then also, my relations from Kano in Lokoja said, "This is the Emir of Kano, Abdullahi." So in order not to offend anybody, I tried to retain Abdu. My grandfather, Sharif Muhammad Ibn Qasim, following an issue with the colonial administration, was exiled to Lokoja by the colonial administration. My father, who accompanied him, made Lokoja their home, assimilating perfectly into the new home. He was loved by his host and was made sanitary inspector, Dubagari. Later, he became councillor of health in Lokoja Town Council. He was a fearless man who stood against injustice by the then colonial administration. In furtherance of his cause, he withdrew from the service of the colonial administration. Every day, the elders gathered in our house to resolve problems in the community. I usually had the everyday task of getting them cola nuts, water for ablution, and at times tobacco. I dare say that staying with these elders made me grow gray hair at a very young age. In fact, in the family, I'm called Soho, means old man. My father died in 1965 at the age of about 96. But even after his death, the elders continued to come to our house for the resolution of disputes. This informal court and the justice I saw dispensed therefrom inspired my career path, culminating in today's event. I am the fourth of my siblings. My father was survived by 3 wives and 5 children, all from my mother. My siblings are Dr. Mohammed Baba Aboki. Can you stand up and recognize Malam Baba Aboki? He's about 96, and he read his PhD at the age of 76. My sister, Jumai Mambo, my other sister, Hajia Ladi Hamisu, she's also here, and my other sister, my junior sister, Fati Isiaku. I was enrolled into the Native Authority Primary School in Kabawa Quarters, Lokoja. I went up to primary 5 before I was relocated to Kano after my father's death in 1965. There I attended the Shauchi Primary School in Kano City. The school was established in 1919, purposely to educate children from the palace of Emir of Kano, Gumel, Kazaure, Hadeja in Jigawa State, Katagun in Bauchi, and Daura in Katsina States, and children from nobility in society. On the completion of my primary school education, I proceeded to Government Secondary School Hadeja. The school was one of the last secondary schools established by the government of Northern Nigeria. I completed my secondary education in 1971 and came out with Division 2 in the West African School Certificate. In fact, we spent 4.5 years, not 5 years, in my time. The life at the Government Secondary School Hadeja was not a bed of roses. GSS Hadeja drew its students from all parts of northern Nigeria. Academic standards were high and competition among students was very keen. We are the pioneer students of GSS Hadeja. Some of my classmates were like late Alhaji Bana Ibrahim, Alhaji Ahmed Isiaku, Alhaji Ibrahim Idris, Alhaji Traiki Ibrahim, Alhaji Ibrahim Khalil, Alhaji Yahuza Mustafa Imam, Alhaji Abdu Aboki Babalawan, and a host of others who rose to the rank of permanent secretaries in the then Kano State Civil Service and also occupied prominent professional positions in the Federal Civil Service of Nigeria. Our principal was Malam Bashir Tukur. He was our pioneer principal. He was followed by Professor Ibrahim Umar and late Malam Adogaram, who became the Secretary of Government in Kano State. Some of our other teachers are Mr. Kwaladade, Malam Ibrahim Abdulhamid, late Malam Muhammad Na'Allah, Mr. Pipi Moltu from Shandam, Mr. J.J. Jamiri, late Malam Yahya Alabura Yusuf, and late Malam Ahmed Gumel, who all deserve my mention. We are very good in sports. I took active part in athletics and was the 880 yards champion in Kano State and a member of the 4x440 relay. I also participated in hockey and volleyball. I represented Kano State in the National School Sports in Ilori and Port Harcourt between 1968 to 1970. In 1972, I was admitted into the Abdullahi Bayero College, ABU campus of Ahmadu Bello University campus, Kano, where I studied for my A-levels, which qualified me to enter the Faculty of Law of the Institute of Administration, Ahmadu Bello University, Zaria, in 1973. I was Vice President of the National Union of Nigerian Students. They called me Vice President, African Affairs. I obtained my LLB certificate in 1976 and proceeded to Nigerian Law School, Lagos, where I obtained my BL in 1977. At the Nigerian Law School, Lagos, I studied among with some prominent judicial officers, like their Lordship, late Justice Muntaka Kumasi, JSC, Honorable Justice Mary Peter Odili, Honorable Justice Mohammed Musa Detijo, JSC, Honorable Justice Eko Ejembi, JSC, late Justice Tijani Abdullahi, JSCA, Honorable Justice Ibrahim Auta, former CJ of the Federal High Court, late Justice Shehu Atiku, former Chief Judge of Kano, Honorable Justice Bala Ibrahim Meriga, former Chief Judge of Kebbi State, late Justice Adamu Aliyu, former Chief Judge of Taraba State, Honorable Justice Abdullahi Mahuta, CJ Katsina State, Honorable Justice Chrysanthus Salong of the Federal High Court, retired, Justice Fadima Akimbami, JCA, Senator Desi Danjuma, Senator Umaru Dahiru Tambuel, Professor Ameze Gubadia, Mr. John Ochoga, Mr. Shola Ojo, Mr. George Itome, Hajia Hashia Ben Umar, Hajia Hassan Usman Katsina, and Abraham Isa, among others. I served in the National Youth Service in the then Gongola State Ministry of Justice between 1977 to 1978. I was attached to the office of the Solicitor General under Mahmoud Muhammad, who later became Chief Justice of Nigeria. His Lordship exposed me to the intricacies of civil service, which later became valuable to me in my career at the Kano State Ministry of Justice and as Chief Registrar of Kano State High Court. Destiny manifested itself by seeing me through a career as a state counsel in my home state, Kano State, where I rose through the ranks in the then Ministry of Justice to attain the position of Director of Public Prosecution, and later appointed as Permanent Secretary and Solicitor General. While as a state counsel, I served as the chairman, Kano State Rent Tribunal. I was also a member of the Kano State Board of Internal Revenue, member of the Kano State Cooperative Bank, and member of the Kano State Drug Abuse Committee. I was one of the youngest permanent secretaries and solicitor generals in Nigeria, being only 7 years at the bar at the time of my appointment. My appointment was on merit based on the Elwood grading theme recommendation of 1964. However, the appointment was truncated as a result of the military takeover. I was seconded to the Special Investigation Panel under the office of the DPP Federation, Mr. Nwazoje. We worked together in the panel with late Mr. Fedilis Nwadialo, SAN, and some eminent lawyers. I was one of the prosecutors at the Ibadan zone of the Special Military Tribunal, together with late Justice Magaji, late Okaka, Mr. Okaka, late Mr. Ogwadi, and late Mr. Nyawu. In spite of all the pressures, we tried our best to uphold the ethics of the legal profession. I won't forget, Mr. Ganifa Ahumi was the only counsel on the other side that was with us at the Ibadan zone of the tribunal. My advice to all prosecutors is to desist from rushing to file numerous charges. They should look at the strength of the evidence they have, and it's important for them, before going to court, to have done a thorough investigation of the case and armed with credible and reliable evidence that will assist the court to arrive at a just decision. There is no point rushing to court when you are not prepared, as the court in such situation will not descend into the arena to shop for evidence, whereas it should come from the prosecutor. The prosecutor should be well prepared for their case in court. During cross-examination, for instance, prosecutors should avoid asking questions that they themselves do not know the answers beforehand. Prosecutors' questions should only be targeted at extracting answers that will assist the court. Most criminal cases have been lost because of these lapses. Of course, the court cannot be blamed in cases where a prosecutor lost his case because he has not come properly before the court. The opportunity to avail myself, capacity building, the opportunity to avail itself to me, along with other young lawyers, for capacity development in legal drafting in 2002 at the University of Washington, Seattle, in California, USA, and in California, USA. The course covered leadership for law officers from various ministries of justice in Nigeria. My internship during the period was in the office of Senator Bill Green, Democrat from Los Angeles, California, who was the chairman of the Labor Committee of the Californian Senate. Among the beneficiaries of this course were Malang Muhammad Abubakar, I can see him sitting over there, the former chief judge, the former governor of Bauchi State. Honorable Justice Gladys Olotu of the Federal High Court, and let Oyi Diko, former Attorney General of Sokoto and Kebbi States. I came to Kano State Judiciary as a result of my appointment as the Chief Registrar, Kano State Judiciary, during the time of the late Saleh Umar Mujibir, the then Chief Judge of Kano State, between 1987 to 2006. It was quite a challenging period for me. I was involved in the expansion of the lower courts in Kano State. As a Chief Registrar, I was the Chief Inspector of Area Courts. I raised the number of area court judges from 52 to 105. I also established magistrate courts in all districts and local governments headquarters in Kano State. I raised the number of magistrates from 7, all located in the Kano metropolis, to 27 magistrates spread across all the local government headquarters in the state. I also introduced employment of qualified female judicial staff in the registry of the court, some of whom are today justices and judges of the High Court. His Lordship, Honorable Justice Saleh Umar Mujibur, managed judges in Kano State Judiciary like his siblings. He was a father figure to all. He was upright, competent, very patriotic to a fault, to the extent that it was difficult for judges who served under him to move to the Court of Appeal. Thus, some of us stagnated at the State High Court for 20 years without moving to the Court of Appeal. The concern of the late Chief Judge was to avoid a situation where Kano State Judiciary might lose its indigenous judges to the Federal Judiciary. While serving as a judge of the Kano State High Court, I served in the following capacities, among others. I was chairman, gubernatorial legislative houses election petition tribunal for Lagos, Enugu, Imo, Taraba, Nasarawa, Kogi, and others. I was a member of the committee to draft Jigawa State High Court Civil Procedure Rules 2005. I was a special lecturer to the Nigerian Law School for about 10 years. I was also a resource person to the NJI for many years. My appointment came from my appointment to the Special Military Tribunal. My appointment came from the then military regime of General Sani Abacha for me to serve as a judge of the Special Military Tribunal for miscellaneous offenses to cover Kano, Katsina, and Borno states, which I chaired for 4 years. Appointment to serve at the Court of Appeal. I was elevated to the Court of Appeal bench and sworn in on the 6th of June, 2006. I served in Abuja, Enugu, Kaduna, Jos divisions. I became the presiding justice, Jos Division, in 2013, and later presiding justice, Abuja Division, in 2015. While in the Court of Appeal, I served in the following capacities, among others: chairman of the Project Monitoring Committee of the Court, 3-time chairman, Appeal Committee of the Nomination of Senior Advocates of Nigeria, chairman, Chairman Review and Harmonization of the proposed Legal Practitioner Act, member Disciplinary Committee of the Board of Benchers for about 8 years, member Screening Committee, Nigerian Law School, member Publication Committee of the Board of Benchers. I was also made a fellow of the Commonwealth Judicial Education Institute, Halifax, Nova Scotia. As destiny would have it, I was elevated to the Supreme Court of Nigeria in 2020 and sworn in on the 6th of November, 2020. I served in the court until my retirement on the 5th of August, 2022, having attained the ripe age of 70. International conferences attended. I have attended several international conferences, too many to mention. I have just returned from United Kingdom, where I attended the 39th Cambridge International Symposium on Economic Crime at Jesus College, Cambridge University, UK, as well as the Federal Inland Revenue Services Conference on Taxation. I'm also director and board member of the Commonwealth Judicial Education Institute, Halifax, Nova Scotia. In fact, I'm the vice president of the institute. The institute is holding its annual GM today in Ghana, and I wish I would have been there, but for this ceremony. My message to the nation in general and to the judiciary in particular are as follows. I must say with a sense of responsibility that the Nigerian judiciary is a place to be. I am proud of the exceptional performance of the Nigerian judiciary under excruciating conditions. The Nigerian judiciary has exceptionally brilliant judicial officers who are thorough in their knowledge of the law and strength of character. I urge the Federal Judicial Service Commission and the National Judicial Council to place greater premium on the merits than national character and other primordial considerations in the selection and appointment of judicial officers. The judiciary is blessed. The failure to accord priority to merit has the effect of demoralizing excellent and hardworking judicial officers. The current condition of service of the judicial officers in Nigeria is pathetic. As at today, the salary of Justice of the Supreme Court of Nigeria is a little above $1,000. This is the highest court of the land. The lower courts obviously receive less. This is grossly inadequate. I call for a quick and immediate improvement of salaries and conditions of service of my learned brothers. I also call on all those who are in charge of administering the funds allocated to the judiciary in this country to be prudent, transparent, and accountable. I would also like to use this occasion to call on the National Assembly to consider amending the Constitution and other extant laws to reduce the number of appeals coming to the Supreme Court, particularly in election-related matters. In this regard, it is my considered view that only appeals relating to presidential election should come to the Supreme Court. Others should end at the Court of Appeal. This call is of utmost importance in order to lessen the heavy burden of the justice of this court. Also, the Apex Court is inundated with frivolous, vexatious, and needless appeals, mainly filed by counsel seeking to meet the requirements for the conferment of the rank of senior advocates of Nigeria. I therefore call on the Honorable Chief Justice of Nigeria and the Legal Practitioners Privileges Committee to review the requirements for the conferment of the rank of SAN to the extent that it will reduce the unnecessary pressure on the court. There is need for us to note that the Supreme Court of Nigeria is a policy court which should only deal with matters of complex legal nature, and so should it be. I must use this opportunity to call on all Nigerians, my fellow countrymen, to always avoid stressing negativities about the country as much as possible. We should try and portray our country in good light. There is no country in the world that does not have challenges. We should therefore not run down our country. As much as possible, we should always try to have the interests of our country in everything we do. We should always pray for the country and its leaders. Special thanks and appreciation to relatives, colleagues, and mentors. I give thanks to the Almighty Allah that made it possible for me to see today, as I bow out of the bench of the Supreme Court after attaining the retirement age of 70 years. I don't take God's sustenance and many benefits that He gave to me on earth as for granted. I must at this point express my deepest appreciation posthumously to my beloved parents, Malam Isiaku Aboki and Hajiya Kaka Kubra, for all they have done to bring me to life and attaining this height. this height God Almighty has taken for me, may their gentle souls continue to rest in peace. May God grant them al-Jannatul Firdaus. Amen. There is need to acknowledge with many thanks for a few of those who made my judicial journey memorable, especially my beloved wife, Honorable Justice DJ Aboki. My 5 children, namely Hadiza, Chief State Counsel in the Federal Ministry of Justice, Mohammed Awal, Accountant of the Federal Inland Revenue Services, Ishaq Aboki, Magistrate in Kano, Hawa Ummi Aboki, Magistrate in the Federal FCT Judiciary, and Abubakar Sadiq, law student at Base University, Abuja. I pray that you all experience greater success in your chosen vocation. My senior brother, Malam Muhammad Baba Aboki, the Megari of Lokoja, Alhaji Muhammad Kabiru Mekarfi III, my sisters, Jumai Mambo, Haji Alhaji Hamisu Meyali, Haji Fati Isiaku, I thank you so much for your love and support. The role of our mentors, all the Chief Justices of the Supreme Court of Nigeria, in particular, late Justice Dahiru Mustafa, Justice Mariam Aloa Mukhtar, my mentor, Honorable Justice Mahmoud Mohammed, and Honorable Justice Ibrahim Tanko Mohammed, the former President of the Court of Appeal, particularly Honorable Justice Umar Farouk Abdullahi, and Honorable Justice Zainab Adam Balkachua, who I have served and learned a lot from, deserve my mention. I also appreciate the acting Chief Justice of Nigeria, my Lord, Honorable Justice Olukayode Ariola, and the President of the Court of Appeal, His Lordship, Honorable Justice Monica Dongwe Menson, Honorable Justice Suleiman Galadima, Honorable Justice Amir Sunusi, and others. For their positive role they played in my judicial journey. My good friends and associates, Honorable Justice Bola Ahmed Tinubu, His Excellency Malang Amin Ntata, Alhaji Amin Ntata, Alhaji Aliko Dangote, Alhaji Abdul Samad Isaac Rabiu, Honorable Dr. Peter Odili, Honorable Dr. Rabiu Musa Konkoso, Honorable Dr. Alhaji Umar Ganduje, Senator Abdullahi Adamu, Senator Omar Gege, Senator Ibrahim Shekarau, Alhaji Dr. Sule Lamido, Ambassador Amin Wali, Alhaji Simon Turaki, Alhaji Badaru Abubakar, His Excellency Nyesom Wike, His Excellency Aminu Wazir Tambuel, Dr. David Umahi, His Excellency Nasiru Ahmed Erfai, His Excellency Abubakar Nasamu Rakingari, His Excellency Alhaji Atiku Bagudu, His Excellency Alhaji Bello, the Governor of Kogi State, His Excellency Aminu Bello Masari, the Governor of Katsina State, Mr. Ifeanyi Ugwanyi, the Governor of Enugu State, His Excellency Dr. Ifeanyi Okoa, the Governor of Delta State, my good friend Senator Rochas Okocha, whom I can see sitting over there, Senator Aliu Magataka Dawamako, my very good friend also Dr. Alhaji Dahiru Mangal, His Excellency Ibukule Amosu, Senator Barau Jibrin, Senator Kabiru Gaya, Alhaji Sadauna Habib, and Alhaji Baba Aminu Baba Agundi, Air Vice Marshal Muhammad Ndatsu Umaru, retired, General Alilu Akilu, Mr. Misliu Smith, AIG retired, IG retired, Alhaji Ahmed Zaki, DIG retired, Mr. M. Adako, His Royal Highness Oba of Lagos, Oba Akiolu, His Royal Highness, His Royal Majesty, the Emir of Kano, the Emir of Bichi, the Emir of Hadeja, the late Alafin of Oyo, Lamidi Adeyemi III, His Royal Highness, the Emir of Lafia, and the Emir of Ningi, the Emir of Gumel, the Emir of Kazaure, and my friends Alhaji Ibrahim Abu Sule, Alhaji Aliyu Ibrahim, the former Chief Registrar of the Court of Appeal, and Alhaji Aliyu Matawale, and my father, Alhaji Bashir Mahe, the Dalatu of Kano. In the course of my work as a judicial officer, I have had a lot of help from members of the bar. I shall mention a few of them, to wit, Abubakar Malemi, SAN, Minister of Justice, Wole Onlani Pekun, SAN, Latif Fagwemi, Boma Alabi, SAN, ST Horn, Lawa Rabana, SAN, YC Mikau, SAN, John Kari Gazama, SAN, AB Mahmoud, SAN, Ahmed Raji, SAN, Yusuf Ali, SAN, Paul Osoro, SAN, Ricky Tarfa, SAN, Yunus Ustaz Usman, SAN, Sani Hassan Garingabas, SAN, Professor Hayatu Shiroma, SAN, Usman Ugu Sule, SAN, Joe Abrahaman, SAN, Baya Ojo, SAN, Mr. Kanu Agabi, SAN, Ibrahim Sani Mohammed, SAN, Adeboyiga Aomolo, SAN, Mohammed Bello Adoke, SAN, Damian Dodo, SAN, Professor Olarewaju Onadeko, SAN, Ibrahim Isa, and John Ochoga, to mention a few. I wish also to appreciate my colleagues and staffers when I worked at the Supreme Court, where I worked at the Supreme Court and the Court of Appeal, and Kano State Ministry of Justice and Kano State Judiciary in particular. Mrs. Hajo Sarki Bello, Chief Registrar, Supreme Court of Nigeria, Barrister Lami Abubakar, former Deputy Chief Registrar, Supreme Court, Barrister Salihu Adamu Ningi, Deputy Chief Registrar, Court of Appeal, Ilorin Division, Mrs. Christy Noel Haruna, Deputy Chief Registrar, Court of Appeal, Jos, Barrister Mrs. Wendy Nkemadu, Legal Research. She's my legal assistant, and she has worked with me for about 4 years. She's very hardworking. Mrs. Atoyin Blessing, my secretary. And then my driver, Yakubu Sani Gambo, Inspector Emmanuel Kasim, my orderly, and my clerks. May the Almighty Allah reward you, each and every one of you. In conclusion, I wish once again to appreciate the Almighty Allah, who has made it possible for us to be here today. And also make it possible for me to achieve all that I have achieved in life. I appreciate all my colleagues in the judiciary whom I have enjoyed working with. I thank all those who come to honor me today. May Allah reward all of you and take you safely back to your various destinations. Alhamdulillah. Thank you very much.
Yes, for the announcement by the Honorable the Chief Registrar of the Supreme Court, please.
I have the permission of the Honorable, the Acting Chief Justice of Nigeria, to announce that refreshment will be served at the Justice's entrance foyer for invited guests only. Thank you.
I told you that don't have my phone, so I can only.